Welcome back to the Making International Law in Korea video series. In this video, I will be explaining on legal status of United States Armed Forces stations in Korea. Generally speaking, it is not a common situation under international law to have military forces of one nation stationed in another nation's territory. To do so, there should be a special consensus between dispatching country and a receiving country that will serve as a legal basis for the alignment of the military forces. There are other essential elements for the military forces to be placed on duty in other countries, such as the necessity of the maintaining special rules and function as a military force and the necessity of receiving nations being excluded in the internal matters, particularly matters of the exercising criminal jurisdiction regarding stations member of the Army. Thus, a dispatching nation and receiving nation in time of peace times address these issues by concluding a treaty regarding the legal status of stationed armed forces, which is generally called Status Forces Agreement, so-called the SOFA. South Korea and the United States have concluded this type of treaty. After the World War II, the U.S. military forces still stationed in the Korean Peninsula were operation forces in wartime in its formality, and since it was not the military troops that stations by agreement in peace times, its status could not be governed under the SOFA regulation. During this period, all actions of the dispatched U.S. military troops were regulated under the law of war or law of armed conflicts, which regulates occupation forces in wartime under international law. When the South Korean government was established on August 15, 1948, the U.S. military forces handed its control over to the South Korean government and became stationed in Korean Peninsula pursuant to the resolutions passed in the General Assembly of the United Nations, until it withdrew on September 9, 1949. During this time, South Korea and the United States undertook the executive agreement between President of the Republic of Korea and Commanding General United States Armed Forces in Korea concerning interim military and security measures during the transitional period. According to this agreement, U.S. Armed Forces in Korea retained the authority to exercise such an all-operational control of security forces in Korea, and the commanding general attained exclusive jurisdiction over the personnel of his command, both military and civilian, including their dependents. This agreement took effect as soon as the withdrawal of the United States military forces were completed. As the armed conflict broke out in the Korean Peninsula on June 1950, the U.S. military forces came to Korean Peninsula once more, and the legal status of the U.S. military forces stationed in Korea was reinforced. Under the pressing situation of the war, the agreement relating to jurisdiction over criminal offenses committed by the United States forces in Korea between Korea and the United States of America was signed on July 12, 1950, 11 days after dispatch of the first United States military troops to the Korean Peninsula. This agreement mainly deals with the issues of the criminal jurisdiction of the U.S. Armed Forces. This agreement, made in a form of exchange of notes, is quite a simple one, and was also called as a Daejeon Agreement after location where the treaty was entered force. According to this treaty, the U.S. court-martial may exercise exclusive jurisdiction over the members of the U.S. military establishments in Korea, and the U.S. forces cannot be submitted to any about U.S. forces. It is further proposed that the arrest of the Korean nationals will be made by the U.S. forces only in the event that the Korean nationals are found to have committed an offense against the United States forces or any of its members. On May 24, 1952, the agreement of economic coordination between Korea and the Unified Command, the so-called Maya Agreement, was concluded, mainly focused on the economic assistance to South Korea. And one of the articles of the agreement prescribed that it grants the individual in agencies of the Unified Command such privilege, immunities, and facilities as are necessary for the fulfillment of their function within the Republic of Korea. The legal status of U.S. forces stationed in Korea has been regulated by the Daejeon Agreement, even after armistice agreements was concluded on July 12, 1953, which ended the war on the Korean Peninsula. The Mutual Defense Treaty between Republic of Korea and the United States of America was signed in October 1953, which took effect thereafter. The Daejeon Agreement was finally replaced in 1966 by the agreement under Article 4 of the Mutual Defense Treaty between Republic of Korea and the United States of America regarding facilities and areas and the status of United States Armed Forces in the Republic of Korea. This agreement is composed of the main agreements coupled with agreed minute, understanding on agreements and agreed minute, and exchange of letters. The main agreement proposed the comprehensive provisions including criminal jurisdiction, which is the most important feature. These provisions also include claims provisions as well as various related articles to facilitate the areas, entry and exit to the territory, custom and duties, taxation, and labor. Article 22 of the criminal jurisdiction prescribed two instances involving the right to jurisdiction. The first case of the granted jurisdiction happens when the authorities under the Republic of Korea or military authorities under the United States have a right to exercise exclusive jurisdiction, and the second case describes the situation where the right to exercise jurisdiction is concurrent. In the case of the latter, the article proposed the two different situations where U.S. military authorities have the primary right to exercise jurisdiction and where authorities under the Republic of Korea have the primary right to exercise jurisdiction. More specifically, the military authorities of the United States have the primary right to exercise jurisdiction in relation to offenses solely against the property or security of the United States, or offenses solely against a person or property of another member of the United States Armed Forces or the civilian components or of dependents and offenses arising out of any act or omission done in the performance of the official duty. In the case of any other offense, the authorities of Republic of Korea have the primary right to exercise jurisdiction. But practically, in the operation of a right to exercise exclusive the criminal jurisdiction by Korea, the exchange of letters required that any determination by the government of Republic of Korea be provided in writing that jurisdiction be exercised by the authorities of the Republic of Korea to the appropriate military authorities of the United States within 15 days after Korea is notified the commission of an offense. Thus, instances wherein the right to the exclusive jurisdiction was exercised by South Korea rarely occurred. This automatic renunciation right to exercise exclusive jurisdiction has been a subject of much criticism domestically. Thus, in 1991, to redress this issue, the understanding and exchange of letters of 1966 were both terminated, and an exchange of the notes was signed to replace them, along with the new understanding. Pursuant to this new understanding, Korea's automatic renunciation of a right to exercise exclusive jurisdiction was terminated, and the provision that addressed the examples of offenses that gave Korea a primary right to exercise jurisdiction was removed as well. The criticism of status forces agreement continued due to the unsettled issues, such as the custody of the accused remaining with the military authorities of the United States, pending the conclusion of all judicial proceedings, and until custody is requested by the authorities of the Republic of Korea, a limitation on admissibility of evidence secured by the Korean government, the delay of trial proceeding by the accused rights of having U.S. government representative present at trial, and a criteria in deciding official duty in relation to the offenses arising out of any act of omission done in the performance of official duty. Eventually, the two nations amended the main agreements and understanding of 1966 and made a new understanding in year 2001. Pursuant to the new agreement, the provision remaining with the military authorities of the U.S. pending the conclusion of all judicial proceedings were amended to until the accused member of United States Armed Forces or civilian components or of a dependent is indicted by the Republic of Korea. Also, it ensured the prompt presence of the U.S. government representative in order to prevent the unnecessary delay to a preliminary investigation or any subsequent proceedings. There was also an improvement on the criteria of deciding the official duty and its procedure. Still, however, regarding the current provisions of SOFA, there remains much criticism and great demand on its amendment, particularly toward environment, labor, and grant and return of the facilities and areas.